Okay, and this is just a continuation of the HOAs. Okay, and then we also need to let it be known to the best of the seller's knowledge if there's any fuel tanks located on the property, and if yes, we need to complete the following, and we need to find out everything about that fuel tank that there is to know. So they need to disclose that to the best of their ability. So this section here, the tanks included in the sale. Buyer and seller agrees that any tank described above that is owned by the seller shall be included in the sale as part of the purchase price, free of liens unless excluded in paragraph 2 above. So if this tank is leased, then it is excluded. But if it is paid for, we need to know, everything about it, and that it conveys with this property. The seller may use the fuel in the tanks described above through the settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as the settlement shall be included in the sale as part of this purchase price. The seller's use of the fuel in any fuel tank is subject to the seller's obligation under paragraph 8 to provide working existing utilities through this early of the closing of the possession by the buyer. So note, the buyer shall be entitled to conduct inspections to confirm the existence, type, and ownership of the fuel tank located on the property. The buyer is advised to consult with the owner of any leased fuel tank regarding the terms under which the buyer may lease the tank and obtain fuel. So we've talked about that already. It needs to be known. You can inspect it, the tank and the ownership and everything about the tank during that due diligence period. So we need to know if there is a tank on site. Here's another note here. The state law provides that it is unlawful for any person other than the supplier of the owner of a fuel supply tank to disconnect, interrupt, or fill this supply tank with liquid filled petroleum gas, LP gas, or propane without the consent of the supplier. So we just need to make sure whatever is being done is the owner is aware and the owner is pretty much initiating this. Leases. The property is not subject to any leases. If the property is subject to a lease, the buyer and the seller should include either the rental income investigation property provision in the additional provisions addendum. So we just want to know that this property that you're purchasing, is this a rental property for the seller right now? And if it is, then we need to know everything, the rental income, the investment portion of it, all of that, and place that in the additional provisions addendum as well. If you're purchasing this home more so like as an investment, because it's already a renter there. And then we have seller obligations as well. So the evidence of title, payoff statements, and non-foreign status. So this is what the seller needs to agree upon when, as far as their obligation to the sale, the conveying of this home. Have some initials here at the end of this page, and then this leads us into page 10 as well. So the authorization, this is still the seller's responsibility. So authorization to disclose any information, so this is additional seller's obligations that the seller is responsible for, to disclose any information. We're down here in the access to the property. The seller shall provide reasonable access to the property through the earlier of closing or possession by buyer. So, they need to let us do our due diligence. Let us inspect the property. We need to be able to get there, get into the property reasonably. I'm not talking about 12 o'clock midnight, but there should be a time, if they're selling their home, that we're able to go in there and do our investigation. See warning in paragraph 4 above 4, limitations on buyer's rights to terminate the contract as a result of the buyer's continued investigation and the property following the expiration of the due diligence period. We have talked about that enough. You do have the right, after we do the investigation, inspections, to terminate this contract during the due diligence period. You will lose your due diligence fee, whether you terminate during or after, because that is paid directly to the seller for you to be able to do these inspections. You will forfeit your earnest money deposit if you terminate after the due diligence period. Okay, the seller needs to remove the removal of seller's property. So seller shall remove by the date possession is made available to the buyer all the personal property which is not a part of this purchase, the sale of this home, and all garbage and debris from the property. And that's just important to me. You're selling your home. Let's do right, sellers. Remove all of your stuff, because that shouldn't be the responsibility of the buyers. When you are ready to move in, you want to move into a free and clear home. You don't want to have to worry about stuff at the end of the road that hasn't been taken yet. So sellers, just make sure that you take care of everything that you need to take care of, and this house is free and clear, free of debris and all of that stuff once closing, actually a couple of days before closing. And again, this affidavit of indemnification agreement, this is just stating again that the sellers will convey free and clear title. We're going to find out about the title search earlier on in the transaction, pretty much during that due diligence period. By the time that's over with, the attorneys will have already did a title search to make sure that there is a free and clear title. But that is the responsibility of the sellers to take care of any liens previously that is on that property, and they have to take that care of that by closing. So in this section, just kind of repeating what I had just said, the seller is going to take care of any liens on this property, payment of satisfactory of liens. The attorneys will obtain that to make sure that all whatever prior liens, judgments, or anything is taken care of prior to closing. Good title and legal access. So the seller shall execute and deliver a general warranty deed for the property in recordable form no later than settlement. So again, just stating again, sellers, you need to make sure that this is a clear, free title, and this needs to be done the buyers have legal access to this property prior to closing. So let's look at this note. Buyer's failure to conduct a survey or examine title of the property prior to the expiration of the due diligence period does not relieve the seller of their obligation to deliver good title under the paragraph. So sometimes the title hasn't came in or not, and then the due diligence period is over. This is not exempt. This does not get the seller out of the obligation to deliver this good title under this paragraph. So they still have to do it, even though the buyer has not had the time to examine these documents. It's still the seller's responsibility to deliver it. Okay, so if any sale of the property may be a short sale, consideration should be given to attaching a short sale addendum. So if this is a short sale, and that happens a lot too, foreclosures, homes going to foreclosures or short sales, we just need to make sure that we have the necessary addendums attached, from the bank and the lenders, whatever is needed to stay in compliance with what we need to do to sell this property. Okay, Section H, governmental compliances. It is a condition of this contract that the property be conveyed free of any material violation. So we just need to make sure that there's no ordinances, laws, permits, governmental regulations that's against this seller, unless the seller has specifically disclosed such violations prior to the effective date. It is a violation if a violation is discovered and identified after the effective date and prior to closing, then the seller may cure the violations unless otherwise agreed. If seller does not cure the violations prior to closing, then the buyer may choose to accept the violations and proceed to settlement, closing, or terminate this contract and receive a refund of the earnest money deposit and the due diligence fee. So that's like a breach of contract on the seller side. So if there is any type of violation, the sellers, you need to take care of it. The buyers can agree to do that, but of course we would need to put that in some type of writing that they agree to do it. But if they don't agree, they don't have to accept this house with its violations. If that is the case and you don't rectify that, they can terminate, but this is a breach on your side as a seller, and then they'll be due their earnest money and due diligence fee back. So, initials here.